Good evening, everyone. Am I audible to all?
Good evening. Yes, ma'am.
Good evening, ma'am.
Good evening. Good evening. Uh, a very good evening to everyone, and a very warm welcome to the final day of our online faculty development program, which is on corporate governance, business ethics, and legal compliances in the contemporary business environment. Organized by School of Law, Netaji Subhas University, in collab with SADA Law House Private Limited. Hi, myself Asta, and I'll be host for this special concluding session. Over the past few days, we have had the pleasure of hearing the incredible speakers, learning from their experience and engaging in meaningful discussions. It has truly been a wonderful journey filled with insight, reflection, and learning. And to bring this journey to a fitting close, today we are excited to host a panel discussion featuring our distinguished lineup of experts from both the fields of the law and management. But before we begin, we have a small request for all the participants. Please turn on your camera for a quick virtual group photo shoot to capture this beautiful moment with you guys. I request everyone to please turn on their camera for a quick group photo shoot. Let's take a few seconds for everyone to switch on their cameras. Yeah, please smile, everyone. Okay, and it's done. Thank you so much, everyone. Now, moving ahead with the program, it's an honor to welcome our esteemed panel. Hello, am I audible? Hello,
Yes, yes, yes.
Yeah, you
hello,
are
Yes,
audible.
ma'am, you are audible.
hello.
Hello. Yes, ma'am, you are audible.
Hello, am I audible? Actually, I'm not getting anyone's voice
Yes,
actually.
ma'am. Yes, ma'am.
Yeah, you are
Yes, ma'am.
audible, Arthur. Yes,
Yeah,
you are audible.
I'm so sorry for the disturbance. Actually, there was some network issue. So moving ahead, it's an honor to welcome our esteemed panelists for today's discussion. Our first panelist is Dr. Sapna, Principal and Professor at Ramaiah Institute of Management Studies, Bangalore, a highly accomplished academician with over 21 years of experience. She holds multiple qualifications including an MBA, PhD, and MSc in psychology, a postdoctoral researcher, and NAC accessor. She has presented more than 50 papers globally and continues to inspire through her leadership and research. We welcome you, ma'am. Coming to our second panelist, we have Dr. Vinayak, Principal of Ramaiah Institute of Legal Studies, a gold medalist in LLM, and a PhD holder in insurance law. He is an expert in labor law, insurance law, and human rights. His contribution to legal education and academic excellence is truly commendable. We are happy to have you, sir. Coming to next, we are having with us Professor Nitin Rajiv, Assistant Professor at the School of Law, Dayanand Sagar University. He specializes in intellectual property law, trade law, constitutional law, and ADR, knowing for blending theory with practical insight. His commitment to student growth and legal education make him a key contributor in the today's academic space. Welcome you, sir. Last but not least, we are having Miss Anushri, Assistant Professor at Ramaiah Institute of Legal Studies. She holds an LLM in Constitutional and Administrative Law, is pursuing her PhD in law, and has completed a PG program in attribution from NLL Bangalore. Her dedication to legal research and education is truly inspiring. We welcome you, ma'am. Let's give a big virtual round of applause to our panelists. Now, without further delay, let's begin our panel discussion. Participants are encouraged to share their questions in the chat box, which we will take up during the Q&A segment at the end. Over to our moderator to take this discussion forward. We welcome you, ma'am and sir. It's my request to everyone, if they are having any questions with them, they can put it in the chat box. Meanwhile, we have received some questions from the participants. I would like to ask those questions from the panelists. Give me a second, just. Our first question is from question is from Ms. Chandrika Tevatia Raz, and the question is: the corporate governance clause as given under SEBI guidelines is adequate for addressing the issue. Why are we still seeing a lot of scams even though such clauses has been introduced? What could be done so that it can be avoided?
So I think I will take up this. So yesterday I was going in detail about corporate governance and how SEBI, LODR, that is listing obligation regulations, and also the Companies Act of 2013 play a very pervasive role to great extent in preventing unethical corporate behavior across board of directors and management per se. But as we all know, if you are looking into a lot of case studies, we looked into the case study of Yes Bank, we looked into the case study of Infosys, how they have, one of the employees of Infosys, how they have basically pointed out the fact that few of the directors were involved in unethical practices. In looking into few of these case studies, we could see that there are certain gaps as to what is said in the legal system, as in what is said in the Companies Act, and how it is being practiced across the industries. But in the last few years, there have been a significant reduction, I would say, in the kind of white collar crimes. But even then, to a great extent, there are changes which is needed. Specifically, there are two areas which need to be modified under the existing corporate regime. One is with relation to insider trading. The second is with relation to related party transactions. So insider trading have become a very common practice as to how the board of directors, that is why we have learned so far what is the necessity of having such a diverse board of directors. There should be independent directors, there should be women directors, there should be non-executive directors. So when the board of directors are diverse, when they're diversified, it to a great extent makes sure that the decisions taken by the board of directors are ethical to a great extent. But what we can see is a lot of companies are not still appointing their board of directors as to the independent directors and non-executive directors. That is one area where we really need a change. Second is with relation to related party transaction. So related party transaction is when two organizations which is entering into transaction, they are related in some way or the other. They're having some personal or pecuniary interest with the transactions. So once we're able to reduce the kind of to make the actual practice of the policy more rigorous, I think to a great extent we would be able to reduce unethical corporate behavior. So to answer your question, yes, there are changes which are needed, and there is a gap between the actual policy and the actual practice of the policy. And these are the two areas that particularly needed a change, I think, in the coming years. Yeah. I think this answers your question.
Thank you so much, sir, for answering this question. The second question is from Bansika Sinha Roy. And the question is, what is business ethics and law? I repeat, the question is, what is business ethics and law? And this question is open for all the panelists here. Anyone can answer this question.
May I?
Yeah, sure.
Okay, your question is what is business ethics? The first point of question is what is business ethics, right? Business ethics refers to the ethics. That means every time when we are following some rules and regulation in everywhere. For example, when we are going to school, हम लोग जब स्कूल जाते हैं तब we are following some rules and regulations. For example, time, entry time, exit time, everything we follow some rules and regulation. Everywhere we are following this rules and regulation. And during the course of regulations, we have followed some ethics. Similarly, also in business, we have followed some ethics. For example, in business, we are not able, or in our ethics, we are not forcefully to give something wrong. It's hamper our reputation. For example, Nestle, Maggie. मैगी ने जो रेपुटेशन आया था कि समटाइम्स सम कंटेंट विच इज नॉट इज गुड फॉर ह्यूमन बीइंग्स is inserted. The point is that कि वो जो गलत था, after that the Maggie has taken up all the products from the market and try to better his reputation. Similarly, law. In law, we have follow some ethics. That means अगर कोई एडवोकेट के पास जब कोई आता है, कोई क्लाइंट आती है एडवोकेट के पास, तो वो अपना पॉजिटिव एज वेल एज नेगेटिव पॉइंट दोनों बोलता है. फॉर एग्जाम्पल, अगर सपोज किसी ने क्राइम करके आया है, कोई मर्डर करके आया है, तो वो जब मर्डर करके आता है तो वो अपना पॉजिटिव पॉइंट एज वेल एज नेगेटिव पॉइंट दोनों बोलता है. And now it's under the ethics of the advocate to maintain that decorum. ये नहीं होता है कि मैं अपना जो भी पॉइंट है वो जाके सामने के वाले के पास या किसी थर्ड पर्सन के पास या कोई एडवोकेट्स के साथ इन मे बी इन गॉसिप और एनी अदर्स डिस्क्लोज कर दूं. That is the relation between ethics and law. So similarly, business have some ethics and we have to follow this ethics in the course of our work. Thank you.
Okay, I think I would like to take up that question. What is business ethics and business law? So if you take into consideration, business ethics means it refers to moral principles and standards that guide the behavior of individuals and organization in the business environment. That is a business ethics if you take into consideration. And the business law, if you take into consideration, on other hand, encompasses the legal rules as well as the regulations that govern the commercial transaction as well as business activities. Actually, if you take into consideration, it provides a legal framework within which business operate, ensuring that it is going with the compliance laws, it is protecting rights and resolving disputes. So business ethics, in summary, if you say, it is moral principles guiding a business conduct, and business law, in summary, if you take into consideration, it is legal rules regulating the business activities. So thank you.
Added to that, I would like to add another one point. So business ethics is having its wider amplification. So its scope is very wide, business ethics, whereas the law is somewhat limited. The non-following of a business ethics may not attract penalty or punishment, whereas the non-following of the business law definitely will attract the penalties and that leads to a dispute.
Yes. And I think Swapna ma'am can give us a more perspective about business ethics than anyone, ma'am.
Yeah, sure. Thank you, Anushree. Yeah. See, in my perspective, as business ethics goes, it's more of integrity, values, and principles that we follow. But now recently, recent past, it has been redefined, saying that the company themselves have code of ethics. When an employee joins the company, they define the code of ethics, stating do's and don'ts in the company. And see, when we teach, there is something called management by objectives. So in that, we teach about vision, mission, and goals, and what is the code of ethics an employee is expected to follow. So I feel business ethics is more of pertaining to one single organization, because every individual organization, the ethical principles vary. Though the general guidelines of integrity, ethics, and all is the same, but every organization, like even if you take in terms of recruitment policy, termination policy, and probation of an employee, all that changes based on every individual organization. I've heard TCS has a very good culture. On the contrary, I've also heard many IT companies where they fire employees. Even today morning, I was interacting with one of the person from Canada, saying that she was on the roll, and within a few minutes the company has terminated her, and she was asked to submit all her documents and the uh, materials that is pertaining to the organization. So business ethics is pertaining to one individual organization, is what my perspective is. But in terms of business law, as Mr. Vinayak, Dr. Vinayak and Anushi was mentioning, it's like a rule, like where every organization is expected to follow. The law is common for all the organization, but ethics is, what do I say, relative. It's based on how we define. So it is individual or the organization oriented is ethics. But if it comes to business law, it is defined already, where everybody else, whether you like it or not, you're expected to follow. But in business ethics, you can redefine. You can still redefine. Suppose, for example, if you want to terminate an employee, you can terminate without paying the salary. I've heard few companies give 3 months of retention salary, maintenance salary. Like that, they have their own policies and procedures when they terminate. When there is a recruitment policy, similarly, there will be a kind of induction procedure as well. So like that, it is all defined by individual organization. So the difference is, if it comes to business ethics, it is individual oriented. Whether you like it to follow or not, up to the organization. If it comes to business law, all of us are expected to follow, whether we like it or not. That's my opinion.
Thank you so much, ma'am. Thank you so much, sir, for answering this question. Our next question is from Evita Sarkar, and the question is, what are the core principles of corporate governance? And this question is open to all the panelists. They all can answer this question.
I think yesterday I've taken the entire session to explain the 6 principles of corporate governance. The international organization. Specifically, we have seen how the 6 principles were endorsed by G20, where India is a member of G20, and how the 6 principles, why the 6 principles are very significant, because it provides a benchmark as to what are the standardized principles of corporate governance. Because what used to happen before this is each of the countries have their own individualistic perspective of what corporate governance is. And specifically after the international, the World Trade Organization in 1994, after it was established, it was very necessary to have a benchmark as to what is corporate governance. So that is why we have learned the 6 principles yesterday. I think I don't have to go through it, because we have taken an entire session on what are the 6 principles. They are the OECD principles. That is the Organization on Economic Cooperation and Development, the OECD. So these 6 principles are the benchmark. Just to repeat it again, I will just take you through the 6 principles. Just mention the 6 principles. One is, the first principle is with relation to ensuring a basis for effective corporate governance framework. That is why almost all the countries, including India, is having the Companies Act of 2013, the Competition Act of 2002, the SEBI regulations and other regulatory bodies which was established under the Companies Act. That is the first principle. Second is with relation to the right and the equitable treatment of all shareholders, including, that's why we have seen special protection is given to the minority shareholders. There is a specific section in the Companies Act which talks about mismanagement and oppression. That is the second principle. The third one is with relation to institutional investors, stock market, and other intermediaries. So we have seen how these institutional investors, including the mutual fund, I mean, most of us have been investing in a lot of mutual funds. That is the currency of the century. Like we have the HDFC mutual fund, we have the SBI mutual fund, where they have a portfolio. They doesn't just invest in one specific share. They invest in a multitude of shares and stock. And how these institutional investors have a responsibility towards all the shareholders. So that is why they have to actually publish what are the why they have voted for a specific resolution. It has to be made in the public domain. So that is one. That is the third one. The fourth one is very important. That is disclosure and transparency. That's why at the end of every financial year, now the companies are required to disclose their cash flow statement, fund flow statement, balance sheet, profit and loss account. I mean, that is very, very apparent on record. Fifth is the responsibility of the board. Again, we have been talking about it for long. Like why it is necessary for the board of directors to be diverse. Why the 1/3 of directors has to be women directors, independent directors, non-executive directors. The last one is about the sustainability and resilience. We know, that's when we have been discussing the ESG. Very important, that is environmental, social governance. Now, most of the companies have this ESG indicator. So whenever the investors want to invest in a particular company, they can look at the ESG indicator and decide, okay, this company is sustainable, that company is not sustainable. So they can make sustainable investment choices. So these are the 6 fundamental principles, very standardized benchmark principles, which is governing corporate governance. So the panelists are welcome to add to this.
Swapna ma'am.
Sir made it very, very explanatory. I think he has covered everything. So most of the the principles and this thing should be based on, I feel, the standard set, the 6 principles, whatever sir has mentioned, purely based on the like ethical code of conduct and independence. One company would like to, how far the company would like to be highly independent. Accountability is also, I feel, is very, very important. So overall, if you see, the core principles of corporate governance is more towards accountability and to what extent the company will be able to maintain ESG. As sir rightly said, that is a buzzword now where everybody is talking about sustainable and the parameters are totally different based on the sector. So that is what is my opinion. Yeah.
Thank you so much, sir. Thank you so much, ma'am, for answering this particular question. Now, the next question is from Jai Kishore Prasad, and it is to Nitin, sir. That yesterday you talked about ESG, that is the emerging trend in corporate governance and financial management also. My question is the same to yesterday. If the S that talk about works right of ESG only relate to the top corporate and only to those employees who are on the payroll of the company, and then how it will influence the whole society or benefit the society at large. Don't you think that impact of this discrimination between permanent versus contractual will affect governance also? Will there be a good or transparent governance?
Yeah, to talk about the ESG indicator, specifically the yes, which is mentioned, that is social indicator, which is also applicable to employees. So it is basically primarily applicable to the employees in the payroll, as in the employees who are directly enrolled with an organization. But I think the specific question is with relation to contractual workers. Now, this is a very emerging field. Most of the organizations have not made their ESG, especially the S factor, applicable to the contractual workers. And there are very few companies, almost like I don't have any illustrative example to give where contractual workers are treated the same way the workers in the payroll are treated. Those are treated differently. I mean, that is the truth. But in case if they have to be treated equitably or equally, I think the 2 ways which it could be done is one, through the supplier audit. That is, anyway, all those contractual workers will be coming to an organization through a third party. It is to make sure that the third parties are basically those which is having great policies. So when companies like Infosys or TCS hire contractual employees, they should make sure that the source through which the contractual employers are hired, they are following the ethical practices. This is a supplier audit. The second one is to make sure that certain benefits which is given to the employees, the internal employees, to a great extent, at least if not all the benefits are given, very few benefits is also given to those organizations which is not directly in the payroll. But anyway, this is not the direct responsibility of the parent company, but it is a responsibility of the supplier company, whoever is supplying these employees. So that is majorly done through audit. But anyway, this is not being done by a lot of organizations, and you are very right to point out there is an equitable difference in the way contractual workers are treated. Because now we have also know about the gig economy that we are in, where a lot of companies like Septo, Blinkit, they don't have the employees are working for them. They're not in their payroll. Most of the delivery agents that we are seeing, they're not actually, they're basically treated the same way as a contractual employees are treated. But anyway, this is one area I think which we really need to focus on, and for this changes are needed in the regulatory governance. There are changes which needed to be made in the Companies Act, and also SEBI also have to make sure that before all these companies are given a chance to function in the economy, they have to comply with how they treat their contractual employees also. I think that's it. That's my perspective on this.
I want to add a point, Mr. Nitin. The recent developments with Rapido, I'm sure you're aware of it, where government has altered the operations of Rapido, is a classic example for the question, whatever is being posted. And big multinational companies like Volvo, in fact, I got an opportunity to meet Volvo chairman a couple of months before, and they in fact diligently follow this even with the contractual workers as well. As you rightly mentioned, the suppliers had to do an audit, which is actually not happening because the previous question of corporate ethics. See, if I really want to be audited, I should be having some standards. But most of the clients will be more of unorganized sector. They would be operating on a day-to-day basis or on a small standard set by their own small-sized companies. So that is one of the gray area I feel government is yet to touch, to put regulations or to even to regulate. But time is not very this thing. Definitely, probably in the future, they will be able to cover the gray area and make sure that even the contractual workers do come into the sustainability bracket, and they will also get all the benefit of whatever the full-time workers as well get. Yeah, thank you.
Added to that, I would like to add, so there is two categories of worker. One is permanent worker, whose name is there in the master role. Another one are contract workers. Basically, the question is pertaining to whether there is whether the facilities and other things, social securities and other benefits which are provided to permanent employees are not available to the contract employers. Basically, apparently, it looks like a discrimination, but the process of recruitment and the class, the permanent employee class is different, and contract employee classes is totally different. So that's why there shall be some discrimination. Otherwise, both will be treated as alike. Our constitution says like should be treated like, not unlike should be treated like. So like, the permanent employees are definitely entitled for a much better benefits than the contract employers. It doesn't mean that contract employers shall be neglected. At least the minimum what is required to be paid to the contract employers must be paid by the contractor or by the principal employer. So there is one act is there, Contract Labor Regulations and Abolition Act is there, that will to some extent take care of these contract employees either in a government sector or in a private sector. And to employment of a contract laborers are totally prohibited in the nature of work which is perennial in nature, that is permanent in nature. So to some extent, the contract employer can be employed. So ultimately, as ma'am and Nitin sir has pointed out, so it is the enforcing authority has to take care of that. Law is there, no doubt about it, but that has to be effectively implemented. Then only these contract employees will get the better benefit which they are really entitled for that. Thank you.
Thank you so much, sir and ma'am, for answering this particular question. Now, moving ahead to our next question from Asutosh Kumar. And it says, are existing law and regulations sufficient to enforce ethical corporate governance?
Can I take this question?
Yeah, sure, ma'am.
Ma'am.
Of course. See, law is for the people to to take care of corporate governance, but there are always loopholes, right? That's why people take loopholes to take a wrong route and get into all negative things or wrong things, and then sometimes come to limelight, get into trouble, or sometimes they take a escape route and they will not get into the bracket of legal what do I say, punishment or whatever it is. If you see my or the general opinion, if you see, of course most of the companies or 99% of the companies do follow the law in terms of corporate governance in many things, but whether are they enforcing it properly, are they following it properly, or it is only for the sake of documentation, or it is manipulated, only the employer or the organization heads will be able to say. So, in fact, if you see many small sized companies, MSME companies, of course they follow, but in terms of employee structure, where like every 100 employee, there must be one HR, and the employee should not work beyond 8 hours. Are they seriously following it? No. And if you take Big Four, for example, KPMG, Deloitte, and all that, see, there is something called uh, 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 feasible, or probably, the number of hours any employee can be able to work every day, not beyond that. Like, for example, 9 hours, 10 hours. But we hear from our own students, they work for sometimes 13 hours, 14 hours. So it all depends, as I told you, as we mentioned, and all the panelists mentioned earlier, law is already set for the people, but are we really following it? Is what is a matter of question.
To add to that, I need to say there is nothing known as a perfect legal system. So each legal system is learning on a day-to-day basis. That is why we have seen yesterday a few case studies of Satyam computers. So when the Satyam computers scam came up, it is when we understood the deficiencies in the predecessor to the Companies Act, the Companies Act of 1956. It had a lot of innate, problems. So it is when the scam came into light, the regulatory agencies understood, okay, these are the areas in which we need significant changes, right? They introduce a
Correct.
concept of independent directors, introduce a concept of women directors, to have a diversified board of directors. Then came the Companies Act of 2013. Then again, there was the IL and FS crisis, which very recently happened, I think in 2018-19. So that time, again, we have decided to make few changes, specifically in the